everybody. My name is Eric, and I'm on the Vancouver Startup Week team. I'd like to take a moment to acknowledge that we are grateful to be virtually gathered on Indigenous land, regardless of where you are joining us from. I'm grateful to be on the ancestral and unceded territory of the Musqueam, Tsleil-Waututh, and Squamish peoples. I'm privileged to live, work, and play on these lands. First, I'd like to thank you for joining us for BSW 2021, and welcome to Top Legal Tips for Entrepreneurs, Setting the Right Tone from the Ground Up, hosted by Watson Goepel. This session is part of the BSW Founder Track and is proudly supported by Sage Accounting. Sage knows you didn't start up your business to become an accountant. Sorry to any accountants out there. Sage Accounting keeps business organized and running smoothly. Track your cash flow, send out invoices, and get paid quickly. Visit the Sage Accounting booth to access free guides and templates for starting your business finances the right way. Plus, get an exclusive BSW discount if you're ready to switch from Excel. I also wanted to thank Watson Goepel for being our event partner and also a sponsor. BSW could not happen without the continuous support from our community sponsors. During this session, if you have any questions for our speakers, please post them in the Q&A in the Whova session. You can also upvote questions. Now I'll pass the mic over to Anand and Rob, and we'll begin. Thank you very much. Over to you two.
Thanks, Eric. I appreciate it. And good evening, everyone. Thanks for joining us at this presentation. This is actually our third year of participation at Vancouver Startup Week, and we're very excited to be able to connect with all of you virtually again this year. So I guess, yeah, let's introduce ourselves. Let's see if I can get to the next slide here. So by way of introductory remarks, first I want to introduce myself. My name is Anand Athiviraham, and I'm a corporate lawyer here at Watson Goepel. Is my screen sharing working, Rob? Is that okay?
Seems to be fine.
Yeah. Okay. I have a few specialty practice areas, one of them being in technology law. So other than business law, I work a lot with tech companies, and as a founder in e-commerce startup myself over 17 years ago, I went into law after realizing my journey could help other entrepreneurs in getting their legal affairs in order as well. I've been a lawyer for nearly 10 years now and operate our firm's office out in Surrey. I also work with all sizes of companies, so a lot of the issues we'll be covering today are directly informed from my own experience. I'll now turn it over to my colleague Rob to introduce himself.
Thank you, Anand. I'm Robert Galletti. I'm a lawyer now for about 15 or 16 years. I started my career as general counsel of what was then Canada's largest fully integrated film studio, and moved into securities roughly 15 years ago. And I've been practicing at Watson Goepel now for the last few months, where we're building a bold new securities practice and trying to stack the decks to help our clients access the public markets. I spend most of my time acting as a sort of general counsel with a lot of small cap issuers, the companies with market caps between say $3 and $10 million. And I represent companies that are listed and based in both the United States and Canada and elsewhere.
Awesome.
Go ahead, Anand.
Thanks, Rob. I appreciate it. So I'll now mention a few things about our firm in general as well, in case you haven't heard about us before. Watson Goepel is a full-service law firm based out of downtown Vancouver. We have about 35 lawyers who practice in a variety of different areas, such as business law, litigation, family law, and personal injury. We have 2 additional offices out in West Vancouver, as well as in Surrey. We're also able to help clients with almost any legal matter across Canada and the world through our exclusive affiliation with an international network of law firms called Lawyers Associated Worldwide. And this really allows our firm to be a one-stop shop for all our clients. So without further ado, let's get on with our presentation and agenda for tonight. This year's presentation will be focused on growing businesses and what they need to do to be successful. As both business and security lawyers, Rob and I see many companies that neglect to address the key fundamentals in corporate structure and corporate governance. This foundation really must include an effective governance and compliance infrastructure, smart policies and procedures that protect your business and support the overall growth, as well as messaging that sets the right tone and hits the right notes in today's marketplace. So hopefully when at the end of the presentation, you'll be walking away with a couple of those key considerations for you to be successful, regardless of what stage of business you're at. The first topic I'll be covering is about the key considerations that should go into building a proper shareholders agreement. My colleague Rob will then address the overarching principles regarding the culture building and deal readiness. And then he'll be talking about preparing yourself in order to access those capital markets and what that looks like and what that entails. Then we'll be ending our evening with talking about choosing the right counsel, depending on a variety of factors, what kind of firm is right for you. And last but not least, some exclusive legal resources that we've developed for startups that may help you in the next stage of growth. If you have any questions during presentation, please write them in the Whova app, and we'll definitely do our best to answer as many as we can at the end of our presentation. So let's begin. So shareholder agreements is our first topic. And in previous years, I've regularly talked about the essential agreements that are needed in every startup business. And at the top of that list is the shareholders agreement. Arguably, it is not only the single most important agreement that your business needs right at the beginning, but also something that should regularly be reviewed and amended as your business grows and adapts to the marketplace. An agreement that worked, for example, with 3 shareholders may not be suitable when you now have 25 shareholders spread across multiple share classes. So keep in mind that it's a living document and therefore should be reviewed from time to time, depending on what stage of growth and how much investment you may have received and what kind of business you're operating in. Without a flexible and well-drafted shareholders agreement, if your business takes off, it can be really a nightmare to deal with disputes. Both Rob and I have plenty of real-life examples that can really, explain this point. But one real-life example that I think many of you may already know about is Facebook, which was adapted into the movie called The Social Network, and is really a good example of what happens when you don't have a proper shareholders agreement in place. So the key consideration for any business involving multiple owners is to ensure that expectations, responsibilities, rights, and restrictions of each owner are clearly defined in a properly drafted agreement. Kind of a one place that you can see, what your rights are, how you can exit if you need to exit, what happens when you get a sale and an offer, or what happens if you want to involve new shareholders. So really that's the core and the crux of the shareholders agreement. A couple of the key provisions you'd be looking at in a shareholders agreement, it can really come in, the agreement itself can come in a variety of different shapes and sizes. I recently reviewed one, for example, that a client provided to me that appears to be from one of the low-cost downloadable legal form websites. It was not only incoherent and poorly worded, but also didn't contain many of the important provisions that I recommend typically for protecting your company, such as triggering events and drag-alongs and tag-alongs. So really, when you're drafting a shareholders agreement, you want to make sure that it's not just called a shareholders agreement, but really contains the key elements that protect your company, your liability, and the other shareholders as well. The thing to keep in mind, if you could leave with one point out here tonight, is don't compromise on integrity and quality of your agreement, as a poorly drafted agreement can really cause more headaches than it's worth, not to mention potentially hours of litigation should the interpretation of that agreement become an issue, because shareholder agreements, frankly, are often the subject of disputes. So this is why you want to spend the time and effort to get it done right the first time around. Now, what are some of those key provisions that you should be looking for and discussing amongst yourselves in a shareholders agreement? I've listed a handful here that I recommend. I'll start with preemptive rights. Preemptive rights are really important to include to avoid the dilution from subsequent rounds of share issuances. A preemptive right essentially allows existing shareholders to participate before new shares are issued to any other person. And typically, you don't want to have this type of clause, because otherwise, once you're issuing new shares to third-party shareholders, then, or even existing shareholders, you're ending up with a dilution effect, which typically you want to avoid if at all possible. So this is why this type of right kind of makes sense to build in, perhaps with a few carve-outs for exceptions. The next one is a right of first refusal, or something that I like to put as a right of first offer. Those sort of pertain with you have to sell your shares first to the other shareholders in a company before you can go out to a third party and offer your shares for sale. The right of first refusal differentiates itself from a right of first offer in the sense that you don't need a third party offer before getting before offering your shares for sale. In the case of a right of first offer, you can just go ahead and say that I want to sell my shares for X amount of dollars. Are there any takers, type of thing, with a right of first offer. With a right of first refusal, you're typically bound to get a third party offer first before you can present it to your other shareholders to see if they're interested to take it on themselves. A drag along and tag along right is they typically sometimes go together, but a drag along is especially important, especially for the startups and growing companies these days, because it prevents minority shareholders from holding the company hostage, so to speak, when you receive a third-party offer that wants to acquire the full company, but now you might be stuck in terms of convincing everyone that it's actually a good deal or in the best interest of the shareholders to accept the deal. So a drag along forces all the minority shareholders to join into the majority and accept the terms of the sale. And usually a percentage like 66% or 50% or something in between could be set as a threshold to allow for such a right to be triggered. The tag along is the opposite of it in some ways, in the sense that it's the opportunity for minority shareholders to join in with the majority if there's a third-party offer. It prevents essentially the minority shareholders from being stuck holding shares in a company in which the majority now is owned by someone else completely different from what they signed up for. The other aspects to shareholder agreements, so you could deal with board of directors, setting meetings, what that entails, what are quorum requirements. Perhaps if you're a smaller company, you want to make sure that each shareholder is entitled to nominate a director to the board in order to conserve your right and ability to participate in those types of meetings. You might want to set up special committees, and as Rob will mention as well, potentially if you're growing and you might have auditors involved, and you might want to form a special audit committee, etc. There might be other special matters in which you might want to set certain thresholds. So for example, you might not want to allow for the alteration of the company's articles, or for the company to obtain third-party financing in a large amount unless a certain supermajority of either directors or shareholders approve that transaction. So really the shareholders agreement can be formulated in a way that protects not only the shareholders, but also the directors from certain decision making, so that you're not just relying on, let's say, a simple majority, but also perhaps some other threshold that might make it a little bit more, in order to get more consent from your co-shareholders or co-directors. The other aspect that is often forgotten, like I said, in some of the standard boilerplate shareholder agreements, are triggering events. So this is really, what happens if a shareholder dies, or what happens if a shareholder becomes bankrupt or simply divorced. You want to make sure that the person's shares who are triggered are offered for sale to the other shareholders in order to prevent a situation where you might have the spouse of a shareholder who has really no idea about what's going on now holding shares in a company that they may not be involved, that they may not want to be involved in, or might cause some friction amongst the other shareholders that are existing. So the triggering events section is something that's really critical, and you can put in things like, for example, if one of your shareholders is also an employee of the company and they did something really bad as an employee, you want to make sure that you're not stuck dealing with them as a shareholder and they're forced to sell their shares if something to do with their employment is terminated. So this kind of section becomes very handy for you to ensure that the shares remain with whoever you want them to remain with, and prevent unintended consequences when those events happen. Insurance, again, something that should be discussed early on, is especially if you're running a business, you want to make sure that the shareholders, or perhaps the key shareholders or the key directors or the key players in the business, have insurance in place, policies basically that are taken out by the corporation in favor of the for the benefit of whoever it's protecting, if it's a shareholder. And the reason you want that is if someone passes away, then basically their value that they have for their shares, you might not be able to pay it as a corporation, because now the corporation might be forced to buy out that deceased shareholder's shares. Without the appropriate insurance in place, you might be stuck with not being able to pay that amount. And unless you have a properly drafted clause that allows you to pay, negotiate in some ways with the state to pay it over time, you might not be able to, as a corporation or whoever's left in the corporation, be able to pay that amount out to the beneficiaries or to the state. And this might be an issue, especially if the deceased is, this was their whole business, or this was their whole, kind of their whole business and their whole livelihood. So in order to prevent the deceased shareholders from having nothing, at the end of the day, having the key man insurance is often something we recommend. Obviously, not everyone qualifies for insurance, so that's why it's something that you want to discuss and decide if it's right for you early on. Next, shareholder meetings. You kind of want to make sure you have something similar to this, like I mentioned, for the directors. For example, maybe set a threshold for certain matters that require supermajority approval. And perhaps you might want to decide, how you want to hold those shareholder meetings. Often now we want to be able to use Zoom or other virtual methods to hold those meetings. So, what kind of notice requirements are required? Who can call a meeting? Is it just, can anyone call a meeting, or is a majority required in order to authorize the calling of a meeting? So a lot of things that can be put in here. And last but not least, non-compete and non-solicit clauses. My colleague Rob will go into that in the context of having standalone agreements that govern this, but in the context of the shareholders agreement, it's always useful to have them as well, just to prevent shareholders from suddenly exiting and the business from being adversely affected by that. Especially when it comes to non-solicit clauses, really critical to make sure that existing employees and existing customers are not taken away by whoever is leaving the company. So usually we put like a 2-year limitation in which these sorts of issues can be dealt with, so that once the shareholder exits, they can compete for a period of 2 years or solicit for a period of 2 years. So that's the gist of that. Again, if you have any questions, feel free to ask through the Whova app. And now I'll be passing it over to Rob.
Thank you very much, Anand. And thank you all for joining us. Before I start, I'd like to thank Johanna Mills, our marketing director, and the folks over at Vancouver Startup Week for putting this together. I hope that you'll take Anand's advice regarding shareholders agreement to heart. It's really at the core of your startup. And where do we go from there? You've incorporated, you've got your shareholder agreement in place, your founders are organized, and then we can move over to the first slide. Where does that leave you? One thing to really consider and remember is that Canadian startups like yours are going to have a shorter incubation period than most of their counterparts in larger markets. BC alone represents an overwhelming majority of IPOs, small cap IPOs, and public companies with having a market cap of less than $5 million. And that's brilliant. It creates a dynamic environment rife with opportunity, but also rife with problems, because it means that you're going to bypass a learning curve for developing your culture and establishing your core agreements that most companies might do over the course of years, and you may have to do over the course of months. And a common problem that we see is that new startups will, of course, focus their attention on their business, on their product, on developing their tech, developing their services, but they won't pay any attention to some of these core foundation issues until the very last minute. And that kind of disorganization, a lack of documents, a lack of familiarity with key compliance and governance concepts can create a very chaotic, uncertain corporate culture. And when it comes time to enter into a deal, to attract a new investor, to partner up with an institution, you name it, and due diligence time comes around, it can derail deals very quickly. And if it doesn't, it can make them very expensive. So the cost to remedy these problems at the last minute is going to far exceed, we're talking treble and quadruple costs, the cost of doing them at an early stage. And beyond that, having these policies in place nurtures stability, predictability, good behavior, and productivity at your company. Try and remember that governance practices and agreements have to be learned. In order for them to lead to sound judgment, they have to be internalized. And so you need to adopt them early and get to know them and practice them in order to be ready for a time when your business is going to be more dynamic, so that you can respond to change in deals as they happen in real time. So on that note, we'll move on to the next slide, and we'll try to go through, in the short time that we have here, some of the key elements that I counsel companies to adopt, to invest in at the early stage of their development. Of course, like the shareholder agreement, the employment and contractor agreement is going to be one of the key documents that's going to kind of regulate how people govern themselves in your business. It's going to help them have a sense of place. It's going to help them have predictability in terms of their compensation. And when they're not in place, what we typically see is we see high rates of attrition, we see uncertainty, we see people trying to re-leverage their positions as business circumstances change, and that can create a lot of chaos. Some of the core issues that are covered by the contract, by independent contractor or employment agreements, are things like assignment of rights. So who owns the work product? There's a presumption with contractors that a very narrow portion of what they create is going to be assigned to the company. With employees, things that are performed within the scope of their work are presumed to be assigned, but we need to have clear language about that. Like a shareholders agreement, we like to address non-competition and non-solicitation. There's a tendency for people to adopt very, very broad, bold non-compete clauses that are completely unenforceable. So we like to advise people about the limits of those clauses, what can be enforceable for how long. But having them in place, it tends to put them in people's minds and focus them on the task at hand and not about going next door. Confidentiality is an important one. Depending on the level of sophistication at your company and depending on the number of employees, you're going to have a lot of potential for leaks. And having confidentiality in place in an agreement that's signed gives you some leverage in the case those things happen, and certainly guides people in the right direction. Now, a common problem that we see with startups is, there's a desire not to take on the human resources burden of having employees and instead making people contractors. Well, don't assume that everyone is a contractor, even if you call them one, because the law will tend to err on the side of them being employees if your business is their sole source of income and their primary source of work. So we like to address that and make sure that you don't find yourself suddenly on the hook for unpaid remittances and employment standards issues. Now, something very basic is the asset transfer. documents that will ensure that the assets and property used to carry on your business and funds used to fund the business are properly documented, so that there are no issues about people picking up and leaving the sandbox when things go sideways. I can't tell you how many times this has happened, that clients have built a business using real estate, using property that belongs to one of the partners, one of the founders, or even to employees, using equipment that belongs to employees. People provide informal loans that aren't documented and suddenly decide to pick up and leave, and it can leave you in a very precarious position. So we, of course, like to document those. Related to employment agreements, stock option plans. This is a question for, that comes up a lot. I've seen stock option grants on napkins that leave a lot to the imagination, and you don't want to leave things to the imagination in these circumstances. A typical plan will allocate anywhere from 5% to 20% of your capitalization to a pool. Plans can be rolling or they can be fixed. Both are customary. We like rolling plans that are fixed at a percentage of your currently issued outstanding shares. Having a proper plan in place can help you anticipate key liquidity events like an IPO or a listing. So stock exchanges have a variety of requirements related to option plans, and we like to incorporate those from the get-go. We like people to become familiar with them. Also, adopting a plan at an early stage will help you avoid the need to seek shareholder approval. If you do implement a plan after your initial public offering, once you have a shareholder base, after you're listed on an exchange, you'll have to go to the shareholders for approval. And that can be an expensive, depending on the number of shareholders you have, a very expensive concept. So avoid the uncertainty and get these things in place beforehand. Make sure that your plan is going to anticipate things like capital adjustments, so forward splits and reverse splits, so that everyone has a clear understanding of how their plan and how their options will be adjusted depending on where you're at. One of my favorites is the code of business conduct. And people don't turn their attention to this, or they steal one off the internet and they maybe throw it in their minute book at the last minute and forget about it. But from my perspective, having a really broad and fulsome code of business conduct can really set a standard for your company in terms of how people comport themselves, how your values and your specific corporate values are reflected in the company's documents in a way that will transcend the coming and passing of executives and employees. So we talk about things like these things cover very practical issues. So how to identify conflicts of interest and how to manage them. What procedures are in place for identifying conflicts of interest, declaring them, and managing them, whether or not director and officer loans are permissible. I like to exclude them as a matter of course, but some companies like that flexibility. What are your duties of loyalty? How are employees and executives to navigate opportunities that are related to your business, but that are not directly included or do not arise from your business, that arise from a competitive business? What outside activities are acceptable? Really obvious things like policies for workplace conduct and harassment, insider trading policies. Having all these in place, in addition to more broad issues like what is the corporation's mandate with respect to social responsibility, environmentalism, diversity. We like to see all these things in place. I find they motivate people. They make hiring easier when you can show someone these are our values, this is what we live by. And frankly, if you want to distinguish yourself when it comes time to shopping for investors and partners, these are the kind of things that really inspire confidence. Of course, in addition to having all these other elements properly documented, you want to have all these, having a code of business conduct and ethics in place is going to help you distinguish yourself. An important one is a whistleblower policy. Even if you have 3 or 4 employees, or maybe you just have 2, put one in place. Install a mechanism for people to be able to report transgressions in the workplace or perceived transgressions. Incorporate a non-retaliation clause that means they will not be persecuted for coming to whoever is responsible for addressing their complaint. And putting these in place at the very early stage gives you time to internalize them. and be able to really execute them when it's time as you grow. Finally, governance. Similar to a code of business conduct and ethics, governance policies become mandatory at the time you seek to an exchange listing. And so the basic ones that you're going to require are a nominating and governance committee and an audit committee. Now, the role of the nominating governance committee is to obviously vet potential hires and additions to your board and executive team. Governance committee is going to set out guidelines for how the policies of the company and the board are going to be administered. These require not just individuals, but charters. And I encourage people to adopt committee charters and to form, even if they don't meet exchange requirements at the early stage, to form committees made up of boards of directors and executives, because they're a learned behavior. And you need to learn both your policy, and you need to become accustomed to holding meetings and to rolling out procedures, like in the case of an audit committee, say, what are our accounting verification procedures? What redundancies do we have in place? How are we making sure that, that our finances are being, correctly recorded and monitored? How are we working with our accountants and auditors? And having these things in place will make you ready to jump at the drop of a dime when it comes time to close a deal. So hold regular board and committee meetings. And I wish I could see everyone's face, because I don't have a gauge of everyone's interest, but and this may seem outlandish to you at the stage you're at, or it may be commonplace already. But I know in the case of, when I've worked with startups or societies or nonprofits, at an early stage, going through the motions of holding a board meeting seemed a bit fanciful and a bit indulgent, like kids having a tea party at first. But I can't tell you how important it is. Keeping meticulous minutes and having a record of how decisions are made at the board and committee level in a minute book, when it comes time to turn it over to opposing counsel for due diligence, whether it's for a financing or a listing, is going to really distinguish you. We'll move on to the next slide. So we've got our core documents in place. And so we're ready to potentially access capital markets. The investors, or rather the founders, have maxed out their credit cards. The employees have bought all the stock they're going to buy. Your friends and family have bought all the stock they're going to buy. You're going to have to start looking outside that range of people to finance your company and take it to the next level. So what kind of things do you have to consider? The first thing we advise companies to do is to build and maintain a very, very clear and concise but clear cap table. So that'll allow them to track and understand how ownership of their company will change with each equity raise that they engage in, and allow them to make provisions for dilution and maintenance of control. Now, people find this can be intimidating because it's more of an art than a science. You're trying to anticipate different financing requirements and liquidity events that may or may not happen, and you don't know when they'll happen. You're obviously going to be thrown. A lot of things will occur that are going to cause you to diverge from your original plan. But as a baseline, we'd like to see founding shareholders and employees holding, well, for one, founders, we like to see holding at least 2/3 of the outstanding float. And then we like to see employees holding, 5 to 10% of the balance. There's some flexibility there. And then we like to see anywhere from 5 to 20% allocated to an option plan. And then over the course of your various raises, whether you go through a 2 cent or a 5 cent or straight to a 10 and then a 20 cent round, before a major investment or IPO, you're looking at somewhere along the lines of a 20 to 30% dilution. And that's something that's going to be adjusted, and there are ways to compensate as you go along, but it's important to maintain your cap table from the outset. What securities are you going to offer? We all think of common shares, but there are quite a few different mechanisms by which you can seek to raise money, and those accommodate different risk tolerances and frankly long-term commitment levels. So common shares is an obvious one. Preferred shares, which give people priority in terms of repayments, liquidity, being repaid with what's left of the company if it happens to dissolve. There are a whole, preferred shares can be tailored in any number of ways. Convertible notes, which is quite popular, especially with clients who seek an early listing. There are a lot of lenders on the market who are happy to provide interim financing in significant amounts for the opportunity to convert your shares at a market price, at a then current market price or a discount to a market price. Another common one that's growing in popularity, and Anand, we were talking about this earlier, are simple agreements for future equity, or SAFE agreements. I know Anand's working on one right now, I think. And these are a lot like convertible notes in that, a cash advance is provided to the company, but the valuation of the securities that are granted to repay the grant is deferred until the company achieves a set of predetermined, say, liquidity or valuation events. So it may be that the funds are provided and it's agreed that the investor will receive a number of common shares, and that their price will be determined by, say, an acquisition, say, a valuation upon acquisition, or a valuation upon an initial public offering. So it's a bit of a mouthful, but there's a lot to consider there, and we can certainly help guide you in making those choices. Your next stage is choosing your investors. As a startup, you're going to be bootstrapping, and then you're going to start to look outside. And so early stage, once you've exhausted your core group of directors and officers and employees and control persons, who are controlling shareholders, say. Early stage companies are typically limited to raising from friends and family, or close friends and close business associates is the language of the securities law, or accredited investors. Now, a common mistake is to think that the friends and family exemption is broader than it is. It's actually somewhat limited, and there's no bright line test to determine whether someone qualifies, except that you have to have known someone for long enough that they can determine your capabilities and trustworthiness. And accredited investors, I've set out the criteria there. You need to have someone who's making over 200 grand annually, or 300 with a spouse. They have liquid assets over $1 million, or 5 million in net assets. And we'll move on to the next slide, please, Nan. The important thing to remember, because it's easy to find people who will say that that they easily meet those definitions. It's easy to try and pass people off as close friends and business associates, but we often see people getting into trouble. And you have to be really diligent when you're choosing investors, because investors who are willing to fudge their qualifications are typically the ones who are going to call the Securities Commission when things go sideways, when they don't see a liquidity when promised, when they see your company run into trouble down the goat trail of a startup. So officers, directors, and other company reps are the ones that are responsible for determining whether an exemption is available. And so you need to consult with counsel when you're bringing people on, and make sure that you have documentation in place where people are making their adequate reps and warranties about their capacity to invest and their qualification to invest. Similarly, we see people relying on finders, whether it's their cousin or whether it's a pro, and relying on finders is fine in some circumstances, but it tends to undermine the availability of certain exemptions. So there's a presumption that if you're using a finder to identify an investor, that they're not your friends or family, and that they're not a close friend or a close business associate. And finders, God bless them, there's a lot of respectable professional finders out there, but make sure you know who you're dealing with, and perhaps run them by counsel. So that they know, so the counsel can give you some insight as to whether they're going to proceed in the right way. Now, this is something that comes up, frankly, with every successful company that I've ever worked with. Every successful bootstrapping investor who takes a company from 0 to 100 in a couple of years is that they're great salesmen. And But the kind of skills, they're great salesmen. You know, they're great at making a pitch. They're enthusiastic, and these are all qualities we love and cherish. But in the context of selling securities, that kind of salesmanship, when directed at potential investors, is going to inevitably lead to unhappiness, investor complaints, and typically regulatory inquiries, whether they're just cursory, whether it's a phone call from the Securities Commission, or whether it's a broader investigation. We've seen them all happen, and sometimes they happen even though people have the best of intentions. So it's important when you're communicating with potential investors, even if they're close to you, that you avoid empty projections and promises at all cost. Really start to learn, start on the right foot by learning what constitutes full and transparent disclosure of risk and of facts and circumstances related to your business. You should always kind of live by those mantras, the mantra of full and transparent disclosure in all your investor communications. Now, securities law in this regard is somewhat complicated, but if there's no reasonable or historical basis for a prediction, we're going to achieve, we're going to have sales of this, we're going to have revenues of this. Our product is just like this product over here. They did so well. So by the corollary is that we're going to do so well. That's not a reasonable basis for making a prediction in securities law. Just don't do it. And if you have to do it, make sure that you're using a kind of offering document that discloses all the risk and all the contextual facts for making those presumptions. And that's, of course, something that we guide people in. Go ahead, Anand. Let's move on to the next one. And I'll just plow through this quickly. So we have time for questions. Know your early stage securities obligations. When companies start out, they typically have, as long as you're only selling to people within the allowable exemptions, which are all listed here, you're not a reporting company. You don't have any obligations. And you're what's called a private issuer. So you're pretty much unaccountable to the regulator. The rule of thumb is that once you surpass 50 securities holders, 50 shareholders, excluding employees, former employees, that you now have an obligation to report any issuances that you make to the securities commissions. And these are made by something called a report of exempt distribution. Now, these are they're not complicated in terms of their concepts, but they're difficult to prepare. And if you're late, some jurisdictions don't care. Other jurisdictions will charge you fees of several $100s a day. And if you don't file them, you can also get put on the radar with the Securities Commission, which is something you want to avoid at an early stage. You don't want to call saying, hey, one of your investors called. They're suspicious about what you've done with their money. And oh, by the way, I noticed you haven't filed your report of exempt distribution. Let's look into your books. And that can suck up valuable time and money and costs. So I suggest paying attention to that at the early stage so you don't get caught off guard. Now, on that note, I hope we've answered some of your questions, but I'll let Anand wrap it up, and so we can start fielding a few from the audience.
Thanks, Rob. So before we head on to the next topic, I just wanted to emphasize one thing, if you could take away, and to echo a lot of what Rob said, is you want to make sure you get the proper agreements and good agreements done. But often clients come to us showing an agreement that they've already drafted, or perhaps that they got from a friend or a colleague or off the internet, and they present it to us, and we're often stuck with, trying to figure out exactly what it means, or if it's actually going to be useful, or if it's actually appropriate for the situation at hand. A general thing I like to mention is, in terms of deciding whether this is a good agreement or not, is, if it was formatted clearly, uses concise language when possible, and without, hopefully, any legalese. It really should contain a defined term section, like a definition section, and use any defined terms consistently and throughout the agreement. Often the agreements that, like I said, that you'll find on the internet are the opposite of this, so please be mindful and retain proper legal advice for your time not to be wasted. And that leads into sort of choosing the right counsel, and how do you decide that? I thought, mentioning a couple of these factors would help set you in the right direction. So Um, in terms of researching a law firm and choosing the right lawyer for your business, a couple of the considerations you might look into are, is this firm someone that can grow as your needs evolve? Right now, you might start as a one-person company, but eventually you might be looking to get investors. Not every business law firm out there is necessarily qualified to talk about securities or necessarily know about all of the intricacies involved in raising capital or a lot of stuff that Rob mentioned in terms of corporate governance, et cetera. So it's really useful to do your research and to know whether a firm that you're using now, is it going to be worth to continue with them in the future. There's no issue with switching counsel as you grow, but it's just easier to start with someone that already knows your business. So obviously doing your homework early on will help you in the right, set you in the right direction. Cost is often a factor that comes into place. And, you know, as a startup, you're probably bootstrapping. So this is often a question that comes to us is, you know, how much is this going to cost? Or, you know, what do I need to budget for this? But keep in mind that, you know, you might think that bigger firms may charge more, but that doesn't necessarily mean that the value you're getting from them is any less than some of the smaller firms that may be charging just as much to get or even more sometimes in order to get the same amount of work or value that you're getting in a bigger firm. So sometimes finding the right balance is really critical. It's not just about cost, but really knowing whether the firm that you're working with actually knows what they're doing, has experience in the areas that you're looking to develop your business in, and whether, you know, you're able to work with someone that, you know, rather than being passed around from lawyer to lawyer, whether you're able to, you know, build that relationship so that you're hopefully, you know, able to find that one-stop shop. Now, similarly, you know, something that deals with cost is also size. So a small firm may only be able to handle one matter at a time. So therefore, you know, when you have that big financing that comes through where you need a subscription agreement sent to that accredited investor as of, you know, tomorrow, a smaller firm might not be capable of handling that sort of rush timeline, versus a bigger firm or a mid-sized firm like some of the firms in town. You know, they'll be able to handle that type of transactional work much more easily and perhaps get to you much quicker than a smaller firm might, just because of lack of resources. Expertise, relationship, these I just want to highlight in terms of, you know, perhaps starting points. So you might ask around in terms of your friends and family if they've used a lawyer or had a good experience, but doing some research, and this is where, you know, sometimes researching on the website or the law firm's articles, or to see if there's anything that, you know, points you in the right direction in terms of knowing what the key considerations are in terms of what you're looking for. And if you're able to find some of that information online or by talking to the lawyer that you're consulting with, then perhaps, you know, that might be the start of a good relationship. And really, you know, try and ask those pertinent questions during your initial consultation, because often that's your opportunity to clarify any doubts and to make sure that your initial assessment of that firm is appropriate. And often lawyers will provide a free or discounted initial consultation so that you can sort of make those judgment calls. So hopefully that kind of helps you with, you know, some questions as to whether it's the right fit. And that leads me into our next topic here, which is our final topic. Many people often find it difficult to choose the right lawyer, and they often resort to using poorly drafted or boilerplate agreements from certain online providers that I alluded to earlier today. So knowing those pitfalls and the issues that we often see from clients, we recently launched a new exclusive service from our own firm that seeks to lower the barrier of entry for those legal services. Specifically, this is to help entrepreneurs, startups, and anyone in between with legal documents drafted by our own lawyers at affordable fixed fees. This initiative is called WDirect, and it involves really a simple three-step process. It offers services such as a discounted incorporations. You'll even get a full minute book package, unlike the ones that you'll, if you're trying to incorporate yourself. through BC Online, that's going to be an issue because you're not really getting the full set of documents that you need. We even help with estate planning and startup documents like most of the agreements we talked about today. It's also simple to sign up with an online form that helps you intake all the information, and you can also save the form and come back to it later if needed. So it really helps you with the whole process. Just to give you an idea of the layout of the website, that's how it looks, but it's just a resource that we thought helps entrepreneurs, and really we're trying to lower that barrier for entry and feel that, like I mentioned, it's really a good idea, instead of using those online service providers that may not be BC based, the agreements that we provide are vetted for use in this province as well as federally as well, depending on your situation. So something to look into, and that's all we have for now. So we're open for questions.
Okay, great.
Yeah.
Yeah, thank you so much, Anand and Rob. So we do have a few questions on Huva, so I'll just get started with the most upvoted ones, I guess. So first question, has your work been affected by the increase in equity, diversity, and inclusion initiatives that have become more prevalent in companies in recent years? How will you advise startups navigating these important conversations? Certainly, I have had conversations at my work about this, about what questions can you ask, what questions can't you ask, even things about vaccination right now. You're not supposed to ask people about that. So over to you.
Rob, do you want to take that one?
Rob, you're muted.
Sorry, Eric, can you give us some clarity on that question? Equity,
diversity, and inclusion.
I have to say it's not a concept that I'm incredibly familiar with. Are we referring to diversity and inclusion? Go ahead.
Oh yeah. Well, in terms of I would say ethnicity makeup, making sure that there's equity in, I would say, gender balance in the company, or
thank you.
Language.
Yeah. So has it affected my work a great deal? I can't say that it has. Certainly not in the startup context, because frankly, we still find ourselves in a climate where the vast majority of people bringing companies public tend to represent, traditional demographics, traditional business demographics, at least in BC. But we are seeing, I am seeing more women bringing companies forward, and I'm seeing a conscientious effort as a new generation of entrepreneurs kind of starts to penetrate the market, to make sure that these issues are addressed. And certainly, that alludes back to some of the policies that I was discussing earlier. I do see it in a more pervasive way in the nonprofit sector. I do a lot of volunteer work and working with some nonprofits, and that's certainly a big issue. But the truth of the matter is that a lot of underrepresented groups have difficulty accessing capital. And so initiatives like WDirect, and frankly, working with younger lawyers, is going to help, we hope, lower the barrier to entry, for at least to help people get off the ground. And once they do, the hope is that they'll be able to access capital in an equitable way down the road. We're definitely seeing demographics changing. I hope that answers your question.
Do you have anything to add, Anand, or I can go to the next
Yeah,
question?
no, I think Rob, mentioned a lot of thoughts I had. I know you mentioned something about, employers potentially asking their employees if they took the vaccine, et cetera. We recently, so one of our colleagues practices employment law, and she mentioned that the answer to that is you shouldn't, like, as an employer, you shouldn't be asking that information, because at this point in according to privacy regulations, that it is something that is personal to the employee. Now, that doesn't prevent the employee from sharing it voluntarily, and perhaps at some later point there might be more reasons as to why you might want to disclose that. But I think it's important that that you sort of have these policies in place, because depending on the type of workplace you're running, it's sort of important to get that clarity early on. And I think alluding to what Rob mentioned earlier in the presentation, that, you know, having those policies sometimes would help you protect against those, you know, questions that may arise in the future. So it's a good idea to have those answered.
Okay, great. Thank you, Anand. So we might have time for one more question. So what are some common consequences that you've seen in startups that have not established good practices from the get-go?
Maybe I could take that one. So yeah, I mean, it's been sort of my practice over the last several months, in fact, that I've received client inquiries, and often they send us, you know, what they think is a complete minute book, or what they think, you know, is what the documents that they need, and it's incomplete or doesn't make sense, or doesn't look right, or things are missing. And really the big consequence is cost, because it's going to cost more to fix things rather than doing it correctly the first time. The way we work is usually on a time basis. We're able to estimate better when we do the work ourselves from the get-go, but to bring us something that may be incomplete or inconsistent or doesn't make sense takes additional time to figure out before we can actually get to the root of the problem and resolve it. So I think it's important as a startup, if you're looking at cost, there's really an important consideration as to whether you want to spend that money properly now, early on, in order to get it done right the first time, or if you're going to do it yourself and hope that it's okay, but then take the risk that it might come back to bite you and potentially require more expense to figure out. And that's really the advice that I could give on that point. Rob, do you want to add to that, or?
Yeah, sure. I mean, on a practical note, what I've seen is I've seen people who neglect, you know, who neglect accounting, who neglect corporate documents, who don't have agreements in place. I see them get held hostage when it comes time to do a deal. You know, whether it's a simple investment or whether it's taking on an institutional investor, whether it's time for an acquisition. I see them get held hostage by people. And frankly, I'll be honest with you, if I'm representing someone who doesn't have an employee or a founder whose agreement is not properly documented, I'll encourage them to use that leverage to get what they need. And you don't want to be on the wrong side of that equation. And what happens is you end up having to pay to solve problems. Audits become more expensive. Financial statement preparation becomes more expensive. You're going to run into things like regulatory inquiries, and you better be able to answer in an elegant, efficient way to avoid issues. And so I've seen people lose money, and I've seen people have their IPOs delayed by a significant amount or cost twice as much. So, yeah.
Reminds me of The Social Network, and that was a little while ago.
Yeah, like I mentioned, it's a movie that's worth, you know, it's one of those real life examples of what happens if you're not prepared, right? You know, you sort of have this idea, you kind of have this ad hoc plan, and it really takes off, and now what, right? You know, you don't really have, you're trying to catch up on the legal front, and that's really where it can become very costly depending on how far you're ahead. So.
Yeah, so there's always something to learn from the movies. It's not just Hollywood. So thank you so much for your time with the questions.